be a hardship, an inconvenience, and burden on you because you have your own lives outside of this courtroom. You have responsibilities to your jobs, to your profession, and to your families. You have undertaken the responsibility of jury duty in a remarkable fashion, as do jurors every day throughout this great country. You have made sacrifices, and you certainly have had to endure burdens and impositions, delays, and a case that ran over what I told you you would have to serve. Throughout this trial, you have been remarkable in terms of your patience, in terms of your conscientiousness, and your dedication. You've never been late. You've been here, and you've had a wonderful disposition. You always have been respectful to those of us in the courtroom, and we're genuinely appreciative of it. I certainly know and appreciate that serving on a case of this sort has interfered with your everyday lives, but you undertook the responsibility in good faith. And I again want to indicate, on behalf of our courtroom family in Department 107, as well as those involved in the case, thank you for your time and your efforts. I want to single out the alternates in this case. If you recall, when we met the first time, I told you that the only way to analogize the role of an alternate is a spare tire. Most of the time, you never need the spare, but when you do need it, you really need it. We didn't need spares in this case because the regular jurors were so conscientious, but the 5 alternates also were remarkably dedicated and conscientious, and I want to thank you as well for performing your civic duty. I'm going to ask that you accommodate us a little bit more by going back into the jury room and just relaxing for a few minutes. I and some of our court staff members want to go in and thank you individually for your sacrifices. So once again, ladies and gentlemen, on behalf of all those involved in the case, thank you for being jurors in this case. And again, I want to wish you the very best. We stand for jurors in this courtroom, and it's not standing for them in terms of tolerating them. We actually stand up for jurors, and people want to know why we do that. Well, we do it because we respect you and because we appreciate you. And that's why at every session in this case, we have stood for jurors, and why now again, those of us will stand for you as well. My best wishes. You are discharged and excused.
You were watching it live right here on ABC 7. On the 7th day of November, Dr. Conrad Murray found guilty in the death of Michael Jackson, guilty of 1 count of involuntary manslaughter. He sat expressionless as that verdict was read.
It seemed that all parties involved were expressionless. There was a brief, however brief, moment of someone in the courtroom with a bit of an outburst. Could have been from the Jackson family, but that was quickly muted. Now, it appears as if they're back to business to set a sentencing date, possibly.
Mr. Chernoff, would you like to be heard?
Judge, you're asking about sentencing?
Any motion and probation and sentencing, Dr. Murray has a statutory right to speedy sentencing within 20 court days after today's date, which means on or before December 8th, 2011. I do not believe we have a probation report. We may, but I haven't reviewed any documentation, and I don't think we do. So it's up to you what date.
We were discussing the sentencing, possible sentencing dates, and we were talking about 3 weeks.
If you have a date that you're suggesting, let me know so then I can turn to the people. Please. Defense counsel are conferring.
On November 22nd, is that whole 21st, that whole week is not dark, is it?
We are open on the 21st and the 22nd. We are not in session the remainder of the week.
What about the 22nd? Is that something that you can do?
I can't.
Is that sufficient time for a probation report?
It's
Possible, Your Honor.
What is the schedule with probation on that?
2 to 3 weeks. It's very difficult to get a report within a 2-week time frame. My suggestion is that it be the week thereafter. The problem I have is I'm starting a major case on the 29th. If it means I have to go to the 30th, I'll do that. If we can start on the 29th, I can adjust the case.
Judge, I'm sorry, you said you're starting on the 29th a case? Is that what you're
I can do probation and sentencing on this case on the 29th as 13 of 20 if you want me to.
Yes, Judge, but that will fit everyone's schedule, and Mr. Walgren, I believe, seems to be okay with that, so...
Let me just ask before we go to the next step. Is Tuesday, the 29th of November, acceptable for the people?
It is, Your Honor.
Thank you. With regard to further proceedings in this case and Dr. Murray's status, do you want to be heard on that, Mr. Walgren?
I would, Your Honor.
You may.
At this time, Your Honor, the people would ask that the defendant be remanded into custody. He, as the court is well aware, has had over approximately 2.5 years to prepare for today's date. He's now a convicted felon and has been deemed the causative factor in Michael Jackson's death. At this time, we would ask that he be remanded with no bail pending sentencing on November 29, 2011. Thank you.
Thank you, Mr. Walgren. Mr. Chernoff, I'll hear from you.
All the causative factors for remand do not apply in this case. For 18 months, Dr. Murray has been on bail, has not violated any of the rules of the court, has not been a flight risk, has not been a danger to the community. He continues that way. He has family obligations that he has to take care of. The fact that this was a possibility doesn't mean that those obligations don't need to be taken care of. There's no reason to remand him under the circumstances, and we ask that you release him OR until sentencing date of the 29th of November.
Is the matter submitted, Mr. Chernoff?
It is.
Mr. Walgren?
Yes, Your Honor.
Thank you. The court takes into account the factors in Penal Code sections 1166 and 1272. Throughout this trial, Dr. Murray was presumed innocent, and certainly there is a constitutional guarantee of bail to pre-conviction status. Dr. Murray has been convicted of a felony by the jury. The jurors found beyond a reasonable doubt, unanimously, that Dr. Murray is in fact guilty of the crime of involuntary manslaughter. There is no statutory right to bail based upon this felony conviction. The court does evaluate the defense request for continued release on OR and bail pursuant to the provisions of the Penal Code sections to which I referred. The defendant shall be committed to the proper custody of the county to await judgment of the court upon the general verdict unless, upon considering certain factors, the evidence supports a decision to allow Dr. Murray to remain out of custody on bond. The first factor is the protection of the public. Quite frankly, I feel that that is a significant and demonstrable factor in this case, and public protection, as far as I'm concerned,